Here we go. Good morning, everyone, and welcome to the New Possibilities Hour, part of the Will Work for Food project founded by Natalie Armstrong-Motin in the spring of 2020. Today's August 25th, 2022, and we have a wonderful guest today, Dr. Rachel York Colangelo, to talk to us about post-pandemic juries. As everyone knows, there's no charge for these great webinars. Rather, we ask people to contribute to a food bank if they like what they see. And our audiences have been so generous with food banks around the world in honor of our great speakers. One of the best parts of the program every week is when we announce the running total of contributions to food banks in our speakers' honor. Jean, would you please take it away?
Well, it's my pleasure to do so. Good morning, everyone. $308,688.20. It's just amazing what can come from an idea that somebody can have and then actually implement. And so that's more than 3 million meals served. So thank you all and congratulations to all. So Rachel, thanks for being part of this.
Absolutely.
Thank you, Jean, for that news. Natalie, Sarah, for being our great teammates, all one big team here on the New Possibilities Hour and the Will Work for Food project. And now to our special guest, Dr. Rachel York Colangelo, National Managing Director of Jury Consulting at Magna Legal Services. Rachel has a doctorate in legal psychology from Florida International University and bachelor's degrees in psychology and sociology from the University of Virginia. Her education involved extensive coursework and research training, specifically in the area of jury decision-making. Dr. Colangelo has over a decade of experience in litigation consulting. She has provided litigation support for a variety of civil and criminal matters across the country in the form of jury research, including focus groups, mock trials, damages assessment studies, and community attitude surveys, as well as other trial preparation strategies, such as voir dire consultation, jury selection, witness preparation, shadow juries, and trial monitoring. Dr. Colangelo has consulted on numerous multi-million-dollar and high-profile cases, including in the arenas of commercial litigation, property and contract disputes, antitrust, securities, intellectual property matters, accounting fraud and malpractice, legal and medical malpractice, negligence, personal injury, and product liability. Dr. Colangelo has a wealth of experience in all aspects of litigation consulting, and we're so happy to have her with us today. Magna Legal Services is a full-service litigation consulting firm which does a variety of services, management of electronic discovery, expert witness, providing of expert witnesses, document management, and a whole variety, a whole suite of legal services for lawyers. And although we've had jury consultants with us before, they've mainly been principally on the plaintiff side. And Rachel, as I understand it, is principally on the defense side. So we may get a little different perspective today, and one that I'm sure will be most informative and educational to everyone. So Rachel, if you would please take it away, tell us a little bit about the food bank to which you would like people to contribute if they're in a position to do so. And then the presentation, my friend, the floor is yours.
Thank you so much for that introduction, Jeff. Again, thank you for having me. And on behalf of Magna Legal Services, very much appreciated. The food bank that I've identified is Alive, and it's a local food bank here where I live in Alexandria, Virginia. Alive serves a diverse population in the Washington, D.C. metro area, and specifically in the Alexandria and Arlington areas, and it has a far reach in our community. So thank you so much to everyone who has or who is planning to donate to Alive. It's such a pleasure to be able to present for such a great cause, something maybe a little bit more meaningful than CLE credit. So thank you again to Jeff, Jean, Natalie, and Sarah for including me today. I'm going to go ahead and dive into the presentation. I have a lot to share. as Jeff noted, my colleagues and I at Magna do primarily work on the defense side, not exclusively. I've really tried to keep my presentation today, more neutral or applicable to those who do both plaintiff and defense work. You might hear some of my comments more oriented to what a defense attorney may be focused on, but I think the information is certainly relevant to all. So as Jeff said, Magna Legal Services is a full services litigation services company. I'm not going to belabor it. I just include this to kind of let you all know what we do. And I'm in that second column of jury consulting. So my colleagues and I do focus groups, mock trials, witness preparation, helping to select juries. We help with strategy. Basically, how can we present our most effective case to a jury? That's kind of what it boils down to. So I'd like to start by talking about nuclear verdicts and what we are seeing both now post-pandemic, if we can call it that. Sometimes I wonder if there will ever truly be a post-pandemic world. But I want to talk about the trends that we're seeing now and also what we had been seeing for several years pre-pandemic. So I've got on this slide really just a sprinkle of some what we would consider nuclear verdicts. And these were actually pre-pandemic. The numbers are high, in the hundreds of millions, not as high as some of the verdicts that we've had since the pandemic. A lot of you may have heard there was a recent $1 billion verdict against Ford in a rollover accident case. However, Ford also recently had a complete defense verdict in a very similar rollover case in a different venue. So we're seeing defense verdicts, but we're also seeing very large jury verdicts in certain cases. And we refer to nuclear verdicts as ones that are very high. So I'm not going to go into detail about these different examples. I'll choose the one on the top left, actually the lowest number there, 89 million, which is not low, but in comparison to $1 billion, it seems paltry. The reason I highlight this is that this was a case tried in Texas in which, by all accounts, the defense group, I didn't personally work on the case, but there's been a lot of discussion about this case in the years following the verdict, felt this was going to be a defense verdict. This was an instance involving a commercial truck driver traveling in his lane, not distracted, on the phone, not any of those usual things you might anticipate from a truck driver stereotypically. He's driving in his lane and a passenger truck driving in the opposite direction lost control. There was inclement weather and this other truck loses control, crosses the center line, and there's a head-on collision. As you can imagine, it was a really catastrophic accident. There were terrible injuries, there were deaths. So a very sympathetic case. But the defendant went to trial because they said, look, for once, our driver was doing absolutely everything right. We've got no liability here. How can we be responsible for another vehicle losing control and careening into our truck? Well, the jury felt differently. And when they were interviewed after that trial, the jurors commented that the reason they found against the defendant, the trucking company, was that they felt as the professional, as the business, the trucking company should have pulled its fleet off the road that day due to the inclement weather. The comments were, well, when you have these big trucks on the road, they're like an 80,000-pound weapon. And if someone else is going to lose control, if they smash into a semi traveling at a certain rate of speed, that's going to be catastrophic. So the trucking company should have taken it upon itself to pull the fleet off the road, which is sort of mind-boggling to anyone on the defense side going, are you kidding? That's so unreasonable, so unrealistic. But the sympathy factor for the plaintiffs in this case, and also the both trucking industry and corporate in general sentiment really reared its head in that case. So it illustrates the unreasonable expectations, or if you're on the plaintiff side, high expectations that jurors have for defendants and what that can mean. This verdict was later reduced, but that doesn't get publicized. Only people that were closely following this probably are aware that the verdict was reduced, as many of these huge nuclear verdicts are. What people hear about, both in the public and in the litigation industry, is the original very high verdict. And that's having an impact on the way that juries around the country see these cases. So I've got some statistics here. I'll breeze through these pretty quickly, but this is just illustrating to you all that even pre-pandemic, we've started to see a trend of increasingly high jury verdicts. Again, this doesn't mean that we're not seeing defense verdicts, but when we're seeing plaintiff verdicts, the median or average value of the awards have been steadily increasing since 2015. The chart that you're looking at here illustrates in blue the median value of jury awards that were handed down in a single fatality auto accident. So a very specific type of case they were looking at, but then they compared it to jury awards in an entirely different type of case involving gender or sexual discrimination or harassment. So you can see that in wildly different types of cases, the trend is very similar of increasing verdicts. These are different charts showing that same trend. We start to see in 2015 that the largest jury verdicts are getting higher and higher. The chart on the left is showing the median of the 50 largest jury verdicts recorded in these years. The chart on the right is showing the number of verdicts that were in excess of $300 million. So there's sort of a dip right there in 2015, but thereafter the numbers of these very large payouts increase. So we know that this is happening, and depending on what side of the litigation aisle you sit on, it's a positive or a negative. As Jeff previewed, and I acknowledged, a lot of my work is on the defense side. So our clients see this as sort of a problem, a trend that is alarming. Clearly on the plaintiff side, this is something that's been a positive. What do we think is driving this? There are a few factors that are driving this trend. And a lot of people have wondered, perhaps, did the pandemic contribute to these verdicts? And I'll talk about that. I'm also going to talk about a growing anti-corporate bias around the country, the reptile theory, and a desensitization to large awards that have all contributed to this trend. So starting with COVID, just to kind of set a baseline, the data that I'm sharing with you related to COVID-19 is based on a series of nationwide surveys that my colleagues and I have conducted since March of 2020. So when the world sort of shut down, including litigation in the spring of 2020, we as jury consultants were very curious, how is this major world event going to impact the psyche and the propensities of our juries around the country? So we set out to survey people. And the data that you're seeing here is reflective of that nationwide survey data. So thousands of people have contributed to this data. As of our last survey, about half of those we surveyed have either had or had COVID with a serious complication. So this is not just have you had it, this is someone who actually got very ill. So someone either personally or someone close to them. So about half the country have experienced, significant illness in one way or the other related to COVID. A little over a third of people around the country either themselves or have a close contact who is directly dealing with the pandemic in some way, either a healthcare worker, first responder, or they've joined task forces. In some way, they're directly dealing with it. I would add teachers to this list. We're all dealing with it, but are actively, their job involves constantly dealing with COVID-related issues. 52% of those we surveyed indicated that they either have been or have someone close to them who were an essential worker throughout the pandemic. So a lot of people did lose their jobs, at least for a time, but a lot of people also continued working as essential workers. Now, getting more to the psychology of how COVID has impacted us, I don't think the statistics on this slide will come as a surprise to any of you. But what we're seeing is that about a third of people we've surveyed say the pandemic has made their own personal mental health worse in one shape or form. 61% acknowledge that the pandemic has at least slightly increased their anxiety levels, fear, or depression. So whether they translate that into a mental health issue, about almost two thirds of people around the country say, yeah, I have more anxiety, fear, and depression now than I did pre-pandemic. A lot of people, 68%, feel that things are going, quote, pretty badly or very badly in the country. And about a quarter of those of people around the country think that things are going pretty well. So you've got a quarter of the population saying things are okay, many more saying things are going badly. And 53%, so a little over half, were at least somewhat, if not very angry about the way things are going in this country. That's not just related to the pandemic, it's also related to politics, taxes, gas prices, all of that. So people are a little upset, they're angry. There's a general sense of unrest. 78% of those we've surveyed feel that at least somewhat that there's no end in sight for the pandemic, that this is just dragging on and on. So what does that mean? Why do I share those statistics? It makes a difference to us as jury consultants because we're often focused on people's mental states and vulnerability more broadly. A vulnerable juror tends to align often with a plaintiff, and that is because people identify with those that they have something in common with or with whom they have a shared experience. So someone who has had personal loss or struggle, financial hardship, or feels anxious or fearful will often identify more with a plaintiff than they can with a defendant, and that makes them more plaintiff friendly. So it's been important for us in the jury consulting world to learn how vulnerable are people feeling right now, and are they more vulnerable than pre-pandemic? The answer here is yes. And again, that's probably not a surprise to any of you. Beyond the psyche, people have experienced legitimate financial hardships as well. It seems that people are sort of getting back to a baseline. People are back at work, those that were laid off, but 30% of those we surveyed said their financial situation declined as a result of the pandemic. And 47%, a greater number though, said their financial status experienced at least a slight negative impact. So maybe they didn't feel that that was a true decline, but it had a negative impact. A lot of people think the economy is weaker than pre-pandemic, and 58% indicate they've become more conservative with their own spending. So people are more vulnerable right now due to the pandemic. There's a sense of fear, unrest, anxiety that makes people, as I said, typically more plaintiff friendly, not only because they identify with the plaintiff who has also suffered some loss or harm or injury, but it also can make them more susceptible to strategies such as the reptile, which I'll cover in a moment. The other thing that the pandemic has done is contributed to an anti-corporate bias or an anti-corporate sentiment that we had seen growing even pre-pandemic, and COVID has made that worse. So these are some stats, again, from our research of people around the country. You can see that there's this growing trend. So about 3/4 of people believe that corporate executives will lie and cover up, that even under oath on the witness stand, they will say whatever is needed to toe the company line. So there's a lot of skepticism, a lot of distrust of corporations in general and the witnesses that they bring to litigation. 30% of people around the country think it takes billions with a B to send a message to corporations. Meaning, if I am a juror and I find that this corporate defendant is a bad actor and I'd like to send a message to them more than a slap on the wrist, it might take billions of dollars to do so. Hence the verdict against Ford recently. We've seen billion-dollar verdicts against Bayer, who now owns Monsanto, over the Roundup litigation. So people are thinking in terms of huge numbers, given the large revenue that these companies have. 71% don't believe that jury awards should be capped. They think a jury should be free to send whatever message necessary to a defendant. And 45% admit that they will ignore the judge's instructions. If they think that the law does not comport with their version of justice, the jury will nullify. They will ignore the instructions and they'll do what they feel is right. So when we have clients who say, well, the law is on our side, and if the jurors listen to those instructions, we're going to be in good shape, I have to tell them that unfortunately, a lot of people kind of fall asleep during the judge's instructions, but they also are readily willing to ignore them if they think they need to in order to render the verdict they think is fair. We've asked people over the years who they're more likely to trust versus distrust in a courtroom proceeding. And as you can see on this slide, more people distrust the CEO or CFO, C-suite executives, then distrust the attorneys. So congrats to the attorneys in the audience. You're not the number one, but as you can see, people have a great distrust for corporations. Feeding into the sort of animosity that people have toward corporate America is the shared sentiment that businesses care more about profits than safety. And this is a really common, popular plaintiff theme because jurors walk into the courtroom already subscribing to this idea that businesses cut corners. They don't spend, the 5 extra pennies on a product to make it a little bit safer, that they're looking out for their bottom line more than they are looking out for people. And this sentiment can make people feel angry and feel punitive towards corporate defendants. I mentioned that the pandemic has exacerbated this. We asked people throughout the pandemic, has your feeling about corporate America stayed the same? Has it improved? Has it gotten worse over the last few months? And in early surveys, which you'll see in dark blue here, it was about even. It was kind of a wash. So people said, I'm either my feelings have remained the same, or equal numbers said feelings got better or worse. However, further into the pandemic, so our most recent survey research is showing that more people indicate their feelings about corporations have deteriorated. They've gotten worse. There are various reasons for this. Some of this is people being disgruntled that many workers were laid off or took pay cuts during the pandemic. Some of it was also related to customer service, as you can see here. A lot of people think that corporations have used the pandemic as an excuse, as another reason to provide poorer services, lesser services, or even to raise prices. So this is contributing to that reduced trust in corporate America that people held even before. We've directly asked people what they make of some of these billion-dollar jury awards, and there are a decent amount who say those awards are too high, they're unrealistic, but there are just as many people who say the billion-dollar jury verdicts are either about right or even still too low or still ineffective compared to the profits that these companies are making. So about a third of the jury pool out there thinks that a billion-dollar verdict is appropriate. I'd like to share with you now a very brief clip of a mock jury deliberating. They're talking about what they should award, kind of a total award to this plaintiff. And the juror in the top right corner wearing the black coat is talking, and she's kind of giving her thoughts on this jury's award.
Maybe 15 million is a little excessive, 10 million, but these are, to me, these are rich companies. This is a very big company. It's like pocket change for them to get, this family is suffering.
All right, so we hear comments like this all the time. And this doesn't necessarily mean that she's doesn't like corporate America, but there's also the other side of this in that people understand big companies have deep pockets, and they say things like, it's like pocket change, it's a drop in the bucket. This amount of money will mean everything to a family who's suffering. It won't mean a lot to this company or to the company's insurance company. Jurors recognize or savvy to the fact that businesses have insurance, and likely they're not going to be paying this verdict. It's going to be the insurance carrier, which frankly, jurors hold in even lower esteem than corporations in general. So these attitudes are contributing to some of the high verdicts because people feel like, well, what's it to a company like Ford or Monsanto or Bayer to have to pay out something like this? These attitudes are even stronger in a particular subset of jurors, which is the millennial generation. There's been a lot of attention given to millennials on juries and how they operate. They tend to have a increased distrust of corporate America. Social media activity causes and contributes to a lot of that. Only 19% of millennials agree that most people can be trusted in general, and they put a stronger emphasis on the importance of being ethical, being a good corporate citizen, being accountable, regulations, and safety. I don't have time to go into the psychology behind this, but it has a lot to do with the age in which millennials grew up. school shootings, Enron, a lot of scandals involving corporate executives and a lot of issues involving safety and fear. 9/11 was a pivotal event for that generation. So they kind of came of age in a time where safety and regulations seem to be particularly important. So there's a heightened focus among this segment. A lot of people say, well, I just don't let millennials on my jury if I'm a defendant. That's not really possible anymore. Millennials make up the largest cohort of a potential jury pool in a lot of venues around the country. So millennials are as old as 40 years old now. So we're not able to just strike them all from a jury, but we need to understand where they're coming from. So millennials are some of the strongest advocates for sending a message to a corporate defendant when they feel that the corporate defendant has not been responsible, has not taken accountability, didn't do the right thing. I've got some comments here from millennials talking about damages. So one comment is, it's just money and they have lots of it. This plaintiff should get everything possible. Let's do the right thing. There's a lot of moral discussion with millennials. Let's do the right thing and give him everything. The defendant's a big corporation, so who cares? If we look at data from mock juries, across 32 different jury research exercises, millennials were more likely to award higher damages. So what you're seeing on the left is if you look at the median award in millions of all of the jurors in these studies, it was about $4 million. Teasing out the millennials, their median award was about $6 million. So there is something to the idea that millennials are awarding higher damages. It's important for counsel trying cases to understand that millennials are going to latch on to themes involving personal responsibility, taking accountability, accepting the consequences of one's choices. When you are a defendant, there are often contributory negligence arguments to be made about a plaintiff, and millennials will actually, jump on board with those themes because they feel that everyone should be taking responsibility. So this can be an option or strategies to kind of counteract millennials' negative attitudes toward corporate defendants. Millennials are inclined to distrust authority, distrust expertise, and to do their own research. Sometimes in the context, for example, of a medical malpractice case, millennials are critical of plaintiffs when they say, well, did they do their own research? They just took this doctor's word for it. That also means that they're looking at your experts with a lens of skepticism of, why should I trust this expert? And perhaps they think they know better. Millennials relate more to a loss of enjoyment of life argument than they do necessarily to physical pain. So millennials really value quality of life over a lot of things. And so things such as a loss of mobility that a plaintiff may have experienced are going to resonate with them on the plaintiff side. I mentioned earlier the reptile theory. I'm positive that you're all familiar with the reptile theory and the strategy. It's been a very successful strategy for the plaintiff's bar, and we're seeing sort of the reptile approach in more and more types of cases. The reptile, I think, is probably even more successful now post-pandemic because of that vulnerability that I mentioned earlier. The reptile, as you all know, is sort of designed to tap into people's innate fears and anxieties about feeling safe and secure in their world, and puts an emphasis on safety. So if you've got a jury pool who's already feeling anxious, fearful, uncertain about the future, they are going to be conditioned to sort of buy right into some of those reptile themes that we commonly see. So as part of our survey research, we've been exploring some of these reptilian attitudes, and we know that a fearful juror, when they hear things that and see evidence that make it look like a corporate defendant has been a bad actor, that fear quickly turns to anger. There's a desire to lash out. That's the whole premise behind the reptile, is that we make one case bigger than it is by getting the juror sort of fired up. They get upset, they get angry, they want to then send a broader message. This is bigger than this one case. This is about making a change. generally. And we see that a lot of jurors are primed to feel that way walking into the courthouse. So 84% of people around the country agree that juries should be the guardians of the community, forcing companies to change bad behavior with large damages awards. So people already kind of have this idea, which feeds right into reptile strategies. Similarly, the majority of people that we have surveyed, 81%, agree a jury's job, jury's duty is to keep communities safe. How do you do that? You keep communities safe by essentially forcing a defendant to change its conduct. How are you going to do that? You've got to hit them with a huge verdict that gets their attention. So people agree, again, 81%, that jury verdicts with large damage awards are the best way to get companies to change their behavior. And a lot of people, at least somewhat, agree that the primary purpose of damages is to punish the defendant. So we often ask this question in a different way. Do you think the purpose is to compensate a plaintiff, punish the defendant, or both? The most popular answer is both. But a lot of people feel like my verdict is actually, yes, of course, about compensating this one plaintiff, but more about punishing this defendant and making a change more broadly. So this is an example of what I would consider a reptilian closing, in which this plaintiff attorney did a really good job of kind of inspiring this jury to, quote, change an industry. You have an opportunity to right a wrong that this company committed and to make the roads safer, not just for this county, but for the rest of the nation. So that's inspiring this jury to sort of take action. You can create change, but they know that the only way to do that is with a lot of money. I'm going to play another clip for you all. This is a virtual jury using Magna's Jury Confirm platform discussing a particular case, and I'd like you to hear what some of these jurors are saying.
Well, my thoughts are that the defense blew up a building, and I'm not inclined to give them the time of day. Their market cap is like $10 billion, $11 billion compared to, you know, two people making 50 grand a year. And frankly, I'm just kind of sick and tired of multi-billion-dollar companies trying to screw people over.
So sick and tired of these multi-billion-dollar companies screwing people over. That's what defendants are sort of up against in a lot of venues. Finally, I just wanted to talk about the desensitization to these large jury awards and what that means in terms of anchoring and why it's contributing to these jury verdicts. So we are kind of inundated with frequent media reports of large verdicts and a negative public sentiment about some large corporations, both in the news media and in social media. The public has become desensitized to some of these big awards. So we hear, you know, $1 billion verdict handed down against Ford. Yes, it makes the news. Is it shocking to us anymore? Not necessarily. And these large numbers kind of set a new baseline for juries. So if you're a community member and you hear about a verdict that perhaps someone in your county, a jury in your local community handed down, it then makes the next trial in which plaintiff counsel is perhaps asking for only 50 million or only, 100 million. It makes that seem not so extreme when they hear reports that juries are out there awarding significantly more money in the hundreds of millions of dollars, if not billion. We have seen, there's a lot of research that shows jury awards, verdicts are becoming higher in areas with more economic inequality. So in areas where there is sort of this tension between the haves and the have-nots, we're seeing higher and higher awards. The growth of the social media landscape is amplifying this effect because it makes people have more access to jury verdicts that are across the country and to what might be happening in the litigation world when otherwise people wouldn't necessarily hear those types of things. Beyond news about jury verdicts, people are also hearing really large numbers in other aspects of more casual life. So, for example, sports stars, if people follow sports, they're following baseball, just had to make all of their trades. And there was a lot of news about these big offers being made, declined from the organizations to these players. And when you hear that a sports player is signing a contract for $300 million, that's really desensitizing people to these huge numbers. In the government landscape, we hear about deficits, budgets, spending. And so those numbers, again, are influencing people and setting a new baseline. So we talk about anchors a lot in the jury consulting world, because these high numbers in the public domain become a high anchor from which jurors, the public, kind of think about what a jury award might look like. More specifically, in a particular case, the numbers that jurors hear in that case become anchors for them. So the number that a plaintiff puts out as sort of their request, that this is what we're asking for, becomes the high anchor. If a defendant puts forth a counter figure, that becomes the low anchor. And there is a lot of research out there, again, that shows these anchor numbers have a significant impact on the way that jurors deliberate on damages and their ultimate verdict. There's even research that says arbitrary dollar amounts that are unrelated to the case, but that jurors hear about, influence the size of award judgments. So if they hear about, and this is true for even quantities. So if jurors hear about the billions or trillions of numbers of a product that a manufacturer is selling each year, even without hearing the dollars associated with that, that becomes a high anchor. It starts to create this baseline of very high numbers. So plaintiffs are out there very successfully anchoring juries very early on. In some jurisdictions, a plaintiff counsel can mention, even in voir dire, that they plan to ask for X amount from the jury. And maybe it's not specific, but it might be, I'm going to be asking you for upwards of $10 million, or I'm going to be asking you for tens of millions of dollars. And I need to know, is anyone uncomfortable with that type of figure? What that does is, it allows plaintiff counsel to get off for cause any juror who says, well, I just can't consider that amount of money, that's too much. So now you've sort of preconditioned a jury that's open to that amount of money, but it also starts to anchor them to this high number from the beginning. And that's the context in which jurors are going to be thinking about the case. We know that anchors, whether they are high or low, have more impact when the jury, when they convey what we call a gist. So it conveys the gist of being small or large. When I say the gist, we all kind of know what that means, but there's actually a cognitive psychological phenomenon where people juries tend to think about their damages awards in terms of first a gist judgment. So they decide personally, do I think the jury verdict here, the damages award, should be high? Should it be low, or should it be somewhere in between? That's the first decision that they're making. Then they have to figure out, well, what does high mean? Or what does middle of the road actually mean? So when the anchors that parties are providing to the jurors already convey that gist, they tend to be more effective. I want to share again another snippet of a online jury deliberation. This jury is sort of discussing what their award should be, and let's hear what they have to say.
So what amount is in? Go ahead.
They did hire the actuary or the medical economist to extrapolate that.
Well, we got that from the plaintiff, but we got nothing from the defendant, because the defendant, I imagine, doesn't agree that they owe it. So, I would say,
if they don't agree, would they not have proposed a different number?
they don't agree that they're responsible for future medical.
I think their number is 0.
Yeah, they think their number is 0. So
they don't want anything.
So I guess I've got to, if I had to vote, I would have to vote with the plaintiff on what the future medical bills would be.
So you hear this discussion where the juror who spoke up first had actually been advocating for a defense verdict, and he came around and the jury voted that this was going to be a plaintiff verdict. So he starts off by saying, okay, well, what did the defense suggest? Because in his mind, the plaintiff's request was too high, and he wants to know what was the counter. And the jurors here say, well, there was no counter. they said they didn't owe anything. And so the reasoning that jurors have is, if a defendant didn't give me some other damages figure to consider, then they must agree that if they're liable, the number is plaintiff's request. So absent a counter figure or a low anchor, juries are inclined to give the plaintiff what they've asked for, because the jury says that might feel really high to us, but if the defendant didn't argue that it's too high, if they gave us no guidance as to what an alternative should be, who are we as a group of laypersons to decide this? So I guess we'll go with the plaintiff's number. And we see that play out in a lot of jury deliberations. So, traditionally, the plaintiff is clearly focused on damages, and they're developing the damages case very early on. They're addressing it early on in the trial. The defense more often is focusing on challenging liability issues, and damages, of course, are a consideration, but they're often secondary. And defendants are making these decisions about, do we offer a counter figure to the jury, even though we're saying we've got no liability? That decision is being made sometimes at the last minute. And my recommendation is that it needs to be a consideration from the get-go. The reason defendants are hesitant to put forth this low anchor number is that there are concerns that if you are denying liability, you're making a lot of arguments about why you're not at fault and damages should be zero. Do you lose credibility in front of a jury by then putting forth this counter figure and saying, well, just in case, we're going to give you this counter figure? There is academic research on this that has shown a defendant who puts forth a counter figure is not more likely to wind up with a plaintiff verdict. So that's the concern, is do you walk yourself into a plaintiff verdict by putting this number out there when really you're arguing it should be a defense verdict? Statistics say that there's not a higher chance of a plaintiff verdict when a defendant does that. However, what does happen is that damage awards are significantly lower when the defendant puts forth a counter figure. Research is consistent on this in academia. Our own research in our mock juries is also really consistent with this. And I haven't provided details, but I can show you with cases where we've tested without a counter figure, with a counter figure, the extreme differences sometimes in the awards that juries give. So the research is sort of supportive of defendants using a low anchor just as often as plaintiffs are using the high anchor. They're very powerful. So I'd like to pause here, or stop here rather, and open the floor up to some discussion based on the points that I've covered. So I'll stop my PowerPoint.
Rachel, thank you. This was a tremendous presentation, so much information for us. Let me ask you, first of all, are there geographic differences in terms of regions of the country, big cities, suburban, or are these attitudes and results valid wherever you go?
Really great question. So yes, there are sort of hotspots, if you will, or I'm sure some of you have heard, or all of you have heard of there's a list of judicial hellholes, they call it, that the defense bar keeps, of the worst places for a defendant to try a case around the country. And I'd be happy to share that information. So there are sort of traditionally worse venues. The pattern there is that more urban centers tend to be more plaintiff friendly, and more rural areas tend to be less so. So often defendants are more concerned about trying a case in a place like, for example, Cook County, which is Chicago. Baltimore has a reputation. Recently, Harris County, Houston, has gotten a reputation. So often it's those urban centers that are more plaintiff friendly.
And when you talked about the credibility of lawyers, there was a question in the chat. Do you draw a distinction between plaintiffs' lawyers and defense lawyers? Are they equally trustworthy or untrustworthy, or are there differences?
Really good question. So we find equally, there are certainly differences between presentation style, but I haven't seen a statistically significant difference between people find plaintiff lawyers more or less trustworthy, with one caveat. People know that the defense lawyer is representing a corporation. So if you distrust the corporation, a juror is also likely to carry that over somewhat into their attorney, because the thought is, well, if you're representing this company that I don't trust, then I might not trust you.
And many people on this line are mediators, and we're often in a situation where we're asking plaintiffs whether there might be reasons for them to consider taking a little less, and talking to defendants about why there might be reasons why they might consider paying a little more.
Mhm.
If you could give advice to mediators about what are the things most commonly overlooked by defense counsel, or what are the things most commonly where we might commonly make a difference in helping people make good decisions, what advice would you have for us as mediators?
Yeah, that's an excellent question. So some of the main issues that we see from the defense side are corporate representative, or even just fact witness testimony being a real wild card. If there's a corporate representative who is maybe not knowledgeable, or they gave a deposition that perhaps didn't go well for one reason or another, or if you've got fact witnesses who are not going to be credible or have real problems, that can be one of the accelerants, if you will, leading to a nuclear verdict. Jurors are looking at these corporate reps with a lens of skepticism. And if the representative is not going to perform well in front of a jury, then that's something to consider, where a defendant might need to consider offering more money. There are certain types of injuries that we find result in higher jury verdicts. So injuries that anything involving a burn, explosions, electrical issues, things that really make people uncomfortable. So we all see catastrophic injuries. Those types of injuries tend to make people particularly squeamish, as well as anything involving, abuse or sexual in nature. So sort of the hot button issues, a defendant might really consider the benefit of a settlement to avoid the volatile nature of an emotional jury.
And the kinds of witnesses you're describing, the people, and this could be true either on the plaintiff side or the defense side, the kinds of people who you're concerned are really not going to make a great impression on a jury are often people who are supremely confident that they will make a great impression on a jury, and perhaps they have a big blind spot. You're a psychologist. This is a challenge many mediators face. What are some tips? How can we be effective in bringing to somebody's attention that they may not come across well to a trier of fact, even though they are quite confident that they are super charismatic?
Yeah, we deal with this a lot, preparing these witnesses who can be difficult. I find that the best approach is to be very direct with such witnesses, and that they're not going to really like what you have to say because you're telling them that perhaps they're not this charismatic and really trustworthy, likable person. But I often rely on my experience, having observed many triers of fact in mock jury deliberations. And I think you all as experienced mediators could say, I'm a trier of fact, and I do this for a living. And I'm going to just be very frank with you that to a lay person, to an objective observer, you're not coming across, I think, the way you think you are. And it might make that witness upset. But in my experience, the lawyers have probably been telling the witness the same thing, but they often can't be as direct because it might be their client, right? So they can't say, hey, you kind of come across like a jerk, because that's their client. But as the neutral, I find that the witness can be they bristle when we give those comments, but they also recognize that we're doing it for their own benefit. And then I'm not here to criticize you as a person. I want to put you in a better position for your case, and I'm giving you this advice. So that's sort of the way that I couch it, is I'm here to help you be more effective. And this is not me criticizing your personality. I'm just telling you how triers of fact respond to the types of comments or demeanor that you are giving me. So I would think that you could kind of do the same as a mediator, to say, I've got a lot of experience and I just want to be honest with you so that you can understand the realities.
And does it help to be specific with respect to tone of voice or the way they answered a particular question or part of their
Absolutely.
demeanor?
I find the more specific you can be with that type of sensitive and critical advice, the better. Because with that type of witness who's a little bit out of touch or self-unaware, if you're just very broad and saying you're not coming across well, they can't internalize that. They'll say, what do you mean? And so pointing out a very specific word choice or something that they're doing in terms of body language, they can reflect and say, okay, I did say that. I did do that. And that's something specific that they can work to change versus a global, you kind of seem like a not nice person. That's really daunting for someone to change. So the more specific, the better.
And is it possible for these witnesses, if you are specific, to either rehabilitate themselves or perhaps falsely believe that they can? Do people commonly respond by saying, well, by the time of trial, I'll have this under control?
Some do, some say, well, this is me, and how can I change? And so that's when the very specific advice comes in. And I say, I'm not looking to change you as a person, but there are small things that you can do to be a more effective communicator. That's usually the word that I try to say, the effective communicator. So it's not about you and your personality, it's about how are you communicating. Some people say, oh, I'll do it differently. This is just practice, but in the real deal, I'll do it differently. And I say, well, actually, research shows that the way you do it in practice and rehearsal is exactly how it's going to happen in the real deal. So we better practice it now. Let's put in the work now to be certain. So you'll see that, again, I'm referring back to research and saying there's support for this. It's not just my personal opinion.
So all the mediators on the line will now be saying to people in mediations, we understand there's psychological research that it's a lot harder to change your behavior and your conduct at trial than you think it might be. So quite a good practical takeaway for us. Before I open it up for other people to ask questions, are there other things that you wish mediators knew or you wish mediators would do differently based on your own experience or things that you've heard?
Well, I will share something that, I hear from, I'm not often present at the mediation, so I'm hearing about how the mediation went. And I fully recognize that perspective is probably subjective based on who I'm working with. And we already know that I work most often with defense counsel, but one of the complaints that I hear is that they feel they walk into a mediation and the mediator has already assumed that the defendant should be paying some substantial sum. And yes, the point of a mediation is resolution. And that means, okay, we're going to settle this with some dollar figure. But some defendants have expressed frustration that it feels mediators aren't open to fully considering that perhaps there is no liability. And not to say that they're not wanting to go ahead and pay something to resolve it. But if a mediator sees, wow, I don't think there's anything here, the settlement number should be significantly lower. That's one complaint that I've heard. It feels like some mediators go in thinking, all right, how much is it going to be? And there's less focus on some of the strong liability defenses that they might be putting on.
Thank you. Okay, let me ask, we have a reasonable size and very polite audience here. Jean, let me call on you first, please. Jean, we can't hear you.
Okay, can you hear me now? Okay, sorry, I'd muted in two places instead of just one. So anyway, Rachel, thank you so much. Having been on both sides of the aisle on this, both in practice and as a full-time mediator, I mean, I've heard what you've said and I've experienced certainly a lot of this. Let me ask you though, now from a mediation standpoint, the plaintiff lawyers are used to, some plaintiff lawyers, there's always a modification there, right? Are used to getting bigger and bigger settlements, let alone bigger judgments. So they're coming into mediation with the same mindset, albeit it's for settlement, not for a verdict, but the same approach that they're bringing to the trial, really. And So and we've had speakers like this before on Will Work for Food. Any suggestions or thought processes on ways to manage as the mediators the situation where you would have a plaintiff attorney and plaintiffs then, and because of their attorneys, asking for huge amounts of money. And then, of course, the defense, you're talking just about that now. They're coming in thinking that maybe they're going to win a summary judgment motion or
Right.
or something, or at least owe a lot less.
Sure. I think that putting some of these nuclear verdicts and the large settlements that get talked about into context might be helpful. Meaning, my point is, we hear about big numbers. We don't hear about the defense verdict or a pretty conservative settlement. They just don't get discussed. They're not making the news. I mean, not that settlements are, but I think perhaps if your sense is maybe the plaintiff attorneys are coming in with an unrealistically high expectation, if there are statistics you could offer to say, yes, we've heard about these large verdicts, but those are few and far between. In fact, they get publicized, but the vast majority of cases like this are being resolved for significantly less. So just trying to sort of ground them that, yes, there can be a shot of getting this reptilian jury, the kind of runaway jury, and there is volatility, but there's also the chance of potentially a full defense verdict or a very conservative sum, and trying to give them some context that, look, you're coming to a mediation for the certainty, and with certainty, you've got to make some concessions. This is not a jury. I'm a mediator. I don't get emotional. I'm not going to get angry and upset and punitive like a jury might. And the reason that we're here is for the certainty that you're going to get something now, and you're gambling with a jury. Either side's gambling with a jury, certainly. So that might be my thought, is if you can sort of really try to give them the context of, we all have the pie in the sky dreams, and you hear about plaintiff lawyers getting these big verdicts, but think about the hundreds of verdicts that are handed down in this country that aren't making the news because they're for $300,000 instead of 300 million.
Yeah, I think the old bird in hand is worth two in the bush, or the certainty aspect of it is something that I think resonates with lawyers from both sides.
Right.
Thank you.
Sure.
Okay, we have time for one more question, if anybody would like to speak up. If not, let me ask you here, Rachel, there's some questions in the chat.
Mhm.
Do you have thoughts regarding juror perceptions or biases in cases involving public entity defendants? Do they come across differently than private corporations?
Yeah, they can come across differently. So one big difference is the deep pockets or lack thereof. People recognize that many public entities that are involved in a litigation don't have those same deep pockets, or perhaps they do, but jurors recognize that the pockets are filled by their own tax dollars. So there can be a reluctance to hand down a huge verdict against a municipality, for example, when jurors recognize, I live in this community. What does that mean for me? People are selfish by nature. And so that's a consideration. But in terms of attitudes, I do find that many people have negative attitudes about their own local public entities because there are frustrations about the potholes in the road or the traffic patterns. People always have gripes. And so often public entities are sort of facing the same ire that a corporate entity is. It's just a different category. It's meaning, yeah, this public entity doesn't serve me as well and my family as well as I'd like, rather than the corporate entity, which maybe doesn't have such a personal connection.
Got it. Thank you. Dr. Rachel York Colangelo, this was a tremendous presentation, chock full of wonderful information for lawyers, litigators, as well as people who serve as mediators and arbitrators. I know we have a lot of each on the line. I know that people, if they're in a position to do so, will consider supporting the Alive Food Bank in Alexandria, Virginia. We've got their information in the chat. That's the Alive Food Bank in Alexandria, Virginia. On behalf of the whole Will Work for Food team, Natalie, Jean, Sarah, myself. I want to thank you very much for an excellent presentation. And with that, we are complete.
Thank you, everyone. Have a great day.
Thank you.
Thank you very much.